Hi, thanks for visiting worklawyer.ca. I'm Jeff Robles, a partner with the law firm of Riley and Partners in Ajax and a certified specialist in civil litigation. The topic that I wanted to cover in today's episode is mitigation and how it applies in the context of work. So the areas that I wanted to cover today is, first of all, what is mitigation? Then I wanted to talk about mitigation as it applies to permanent employees or those who have employment agreements of indefinite duration. Then we'll talk about mitigation in the context of fixed-term contracts for employees. And then we'll finish off with how mitigation applies to fixed-term agreements for independent contractors. Now, in my practice, I come across the phrase, the defendant denies that any damages suffered by the plaintiff, which are not admitted and are specifically denied, are excessive, remote, not recoverable in law, and have not been mitigated. Now, failure to mitigate damages is a common defense that you see in court documents like statements of defense. But this defense doesn't apply to cases involving independent contractors in the same way that it applies to employees. So I wanted to start this next section by talking about mitigation principles. So this duty to mitigate damages in an employment context can arise where an employee who has an employment contract or agreement of indefinite duration is dismissed without cause. So that's one area or one instance. The employee in this situation is obligated or has a duty to go out and try to find new comparable work to mitigate his damages, or in other words, minimize his losses. The employee isn't obligated to take just any job that becomes available, but is required to look for a position that is comparable to the one that he had at the time of dismissal, something comparable having regard to his skill set, training, education. The leading case on mitigation is the Supreme Court of Canada's decision in Michaels and Red Deer College, a decision from 1976. And in that case, the Supreme Court of Canada confirmed that an employee has to take reasonable steps to search for comparable employment. But if the employer can show that the employee could have procured comparable employment, but failed to make reasonable efforts to do so, then the court can conclude that the employee failed to satisfy this duty to mitigate. And then, in turn, the court can take this into account when it comes to assessing a reduction in the amount of damages that the employee might be entitled to. Now, in a more recent decision, Benjamin and Cascades Canada, this is a decision from 2017 of the Superior Court of Justice. The court in this case explained that the law requires that the employer must provide evidence that there are comparable employees that the employee may possibly have been hired for had the employee taken reasonable steps to look for work. The employer is not required to prove that the employee would probably have been hired for these positions. So it's the distinction between may possibly have been hired as opposed to probably have been hired. Prior to this 2017 decision, in 2016, the Court of Appeal of Ontario released the decision in Maasland and the City of Toronto. And here in this case, the Court of Appeal emphasized that the assessment of the reasonableness of the employee's mitigation efforts to try and find comparable work is a contextual approach. The employer has to take into account all of the circumstances concerning the employee, such as the distance of the commute that the employee would have to undertake with that replacement position, or perhaps even familial challenges, such as the death of a family member. So it underscores that this exercise of determining whether mitigation efforts are reasonable, it's a subjective one, and it's not a one-size-fits-all approach. So now that we've talked about mitigation principles, I want to take a look at employment contracts of a fixed term. And so these principles that we talked about earlier, while they can be applied to cases involving contracts of indefinite duration, they don't apply in the same way to fixed term employment contracts. And when it comes to mitigation and fixed term contracts, the leading decision is called Howard and Benson Group Incorporated, 2016 decision of the Court of Appeal. And in this case, the Court of Appeal clarified that unless a fixed term employment agreement includes an enforceable provision specifying a predetermined amount of notice of termination, then the employee is entitled to payment of the balance of that contract without any duty to mitigate. So if, for example, the fixed term contract is for a 2-year period, and 1 year into the contract, the employee is let go on a without cause basis, well, that employee is entitled to the remaining 1 year of that contractual term and has no obligation to try to go out and find new work. A more recent decision from 2022, Terrace and the Municipal Infrastructure Group Limited, a decision of the Superior Court, it underscores the importance of having an enforceable termination provision in that fixed term contract. And you might have heard me say earlier in relation to the Howard decision from the Court of Appeal that it has to be enforceable. The document in the Terrace decision contained an early termination without cause provision that sought to limit the employee's entitlements to notice of termination or termination pay, plus any applicable severance pay as prescribed under the Employment Standards Act 2000. However, the document in this case contained an early termination clause that indicated that the employee could be dismissed without cause, rather with cause, and without payment of any kind whatsoever. That ran afoul of the Court of Appeals decision from 2020, Waxdale and Swegon North America Incorporated, where the court in that decision concluded that termination provisions like the one in the Terrace decision were unenforceable attempts to contract out of the provisions of the Employment Standards Act, and more particularly, the provision that says that willful misconduct, willful disobedience, or willful neglect of duty that is not trivial and has not been condoned by the employer is required in order for an employee to become disentitled to notice of termination, termination pay, or severance pay. And obviously, this is a higher standard compared to the standard set out in the early termination with cause provision in the Terrace decision. And since this provision purported to avoid paying statutory entitlements for reasons that fell short of what is prescribed in the legislation, the court concluded that the termination provision as a whole was void. And so as a result, the employee ended up being entitled to payment of the balance of the contract term and without a duty to mitigate, as set out in the Howard decision that we talked about earlier. So we've talked about fixed term contracts as it applies to employees. I want to talk now about fixed term independent contractor agreements. And so I want to contrast those earlier cases with a case from last year, Monterosso and Metro Freightliner Hamilton Incorporated, another Court of Appeal decision, where the Court of Appeal takes a different approach when it comes to independent contractor agreements. In this case, the plaintiff in question sought to apply that same principle in the Howard decision, that the employee is not required to try to mitigate in the case of a fixed term contract. The independent contractor in this case tried to make the same argument that he was not subject to a duty to mitigate. And at the trial level, the trial judge accepted that position. However, the Court of Appeal ended up rejecting that argument, and at paragraph 9 of the reasons for that decision stated, a duty to mitigate arises when a contract is breached, including contracts with independent contractors. So the court made it clear that unless the innocent party to the breach is an employee or a dependent contractor, akin to more along the lines of an employee, the duty to mitigate applies to the innocent party, the independent contractor in this case. So there are some takeaways from all of this case law that we've talked about today concerning mitigation. The first one is that the onus is on the employer in an employment contract of indefinite duration, or when dealing with a permanent employee, to provide evidence that there are comparable positions that the employee could have been hired for, may possibly have been hired for, had the employee taken reasonable steps to look for work. The employer is not required to show that the employee probably would have found comparable work. Secondly, the reasonableness of the employee's mitigation efforts is a contextual approach, considering all of the circumstances surrounding the employee. The third point is that in the absence of an enforceable provision specifying a predetermined amount of notice, the early termination of a fixed term employment agreement without cause entitles the employee to payment of the balance of the contract term and without a duty to mitigate. Fourth, the early termination provisions in a fixed term employment contract will be deemed unenforceable if any part of the provisions in that contract attempt to contract out of the minimum statutory entitlements into the employer under the Employment Standards Act 2000. And then lastly, fixed term independent contractor agreements will be treated just like any other contract, such that the innocent party to the breach, the independent contractor, is subject to the duty to mitigate. So that's the episode for today. If you enjoyed this episode, please be sure to like and share, and follow on Facebook, Twitter, YouTube, and wherever you listen to your favorite podcasts: Spotify, Google Podcasts, Apple Podcasts, and Amazon Music. Thanks again for visiting, and we'll see you next time.